Okay. Good evening, everybody. Thank you for logging in. This is the Medical Society of New Jersey lecture series. We are proud to have our presenter this evening, John D. Fanburg, Esquire. We thought it was timely to talk about the New Jersey Pure liquidation. And so I would be happy to introduce him, and we thank you for logging in. What we will do is we will have a question and answer period at the end. So if you have questions, things that come up, please feel free to jot them down. We use the raise your hand function. So for most people, it's either under the more section. I think at this time, most people know how to do that. But if you have any questions and you can't find it, then you can, you can undo your mic at the question and answer and then let us know. And with that, I'm going to introduce John. So John Fanburg is the managing member of Brach, Eichler, LLC, and he's the chair of the firm's healthcare law practice. With more than 40 years of experience in healthcare law, he advises physicians, hospitals, and healthcare organizations on corporate, regulatory, transactional, and compliance matters. Recognized as one of New Jersey's leading healthcare attorneys, John is a frequent speaker on legal and legislative issues affecting the healthcare industry, and we are very honored to have him tonight as our speaker. And with that, I give you John Fanburg.
Great. Thank you, Doctor. And I want to thank Josh and Larry for having me here tonight and helping to support the program. Also want to make mention of my good friend Henry Kane, who is very active and has been for many, many years in the med-mal arena, and he's provided me with some information that I want to share with you. So I want to give a kudos to Henry and for appreciation for his support. So let me kind of jump into it. And basically, NJ Pure, depending upon how long you've been with them, was licensed to provide medical malpractice insurance in New Jersey going back almost 23 years. But about 3 years ago, began to experience financial stress point.
John, your microphone just went on mute.
I didn't touch anything. Thank you very much. So the NJ Pure has been licensed to issue med-mal insurance since January of 2003. The recent couple of years began to have a declining financial situation. And there was activity earlier this week, which I'll come up to in another minute or two. At the moment, in light of being in liquidation, policyholders have unfortunately very limited protections, and we'll go through the scenarios associated with that. So what happened to NJ Pure? Well, they began to suffer. Basically, payouts were beginning to become greater than the money that was coming in. In February of 2023, they voluntarily agreed to cease writing new med-mal policies. And towards the end of 2023, they sent non-renewal notices 60 days in advance for the policies that were being non-renewed effective November 30th of 2023. They placed the remaining liabilities into a runoff mode to satisfy existing claims. And as of December 31st, 2025, New Jersey Pure had no new policies in place. Cash flow continued to decline, and they began to miss some of the regulatory requirements in terms of the surplus that was required versus the capital. And you can see from the slide, the state laws required them to have in excess of 2.2 million, but their capital was below that 2.177. Independent actuaries came in to evaluate how much was there to estimate what was anticipated to be paid out based upon pending claims, and things began to go to get worse. In 2025, last year, their annual financial statement reported a sudden $13 million drop in surplus, which gave them a negative surplus of approximately $10.8 million. The deficit triggered a requirement for the state to begin to intervene in 2026. And as a result, NJ Pure attempted to restore their capital. If you are a subscriber, you received a copy of the letter. I think that was sent out in middle of April. And essentially, the letter said, unfortunately, we're writing to you directly because the situation is urgent, requires your immediate attention. NJ Pure is determined that it is currently insolvent and absent corrective action is expected to be placed into liquidation within the next 30 days. If that occurs, your professional liability coverage would be reduced from $1 million per claim to a maximum of $300,000 under New Jersey's Guarantee Association. The letter goes on and basically seeks its subscribers to contribute money to NJ Pure to try to make it whole again. There was another FAQ urgent policy notice that went out later that month where they were looking for financial commitment due May 1st, presumably so that they could go to court or deal with the regulators to stave off an insolvency. And we're asking for $99,240 per subscriber, looking to raise $12.8 million. Not sure what effect this letter had, whether they got one, two, or many people to contribute. I know probably leadership of the medical society, Josh and Larry, were perhaps contacted. I know Henry was contacted. I was contacted. Many people were wondering, what do we do and how should we be responding to this? I think most of the real answer, unfortunately, was you may be throwing good money out after bad. Now the Department of Banking and Insurance jumps in. So DOBI has jurisdiction over all insurance companies in the state. This isn't the first company to go into insolvency, so there is a bit of a history here in terms of how the state acts and what DOBI's responsibility is. So when an insurer is insolvent, the commissioner of the Department of Banking and Insurance goes to court and, depending upon the situation, asks the court to do one of two things. Go into a rehabilitation where the state takes the company over to try to save it, find other alternative sources of financing to make them solvent, or they file an action to cause a liquidation, which is basically an orderly wind down and going out of business. At that point, the commissioner of the Department of Banking and Insurance basically takes over the running of the company, assumes administrative responsibility as well over the remaining assets and any of their obligations. The commissioner determined that NJ Pure was insolvent. The commissioner petitioned for liquidation. This was filed in New Jersey Superior Court. And on July 27th, the court entered DOBI's proposed order. So that was just a couple of days ago. So tonight's program is very timely. With regard to the order from the court out of Mercer County ruled as follows. The commissioner is hereby vested with title to all assets of NJ Pure, including but not limited to any of NJ Pure's contracts, causes of action, books, records, bank accounts, certificates of deposits, funds, securities, or other funds, and all real or personal property of any nature, including furniture, fixtures, office supplies, wherever located, including such property of NJ Pure which may be discovered hereafter, and is hereby directed to take immediate exclusive possession of the control of them. The order also provided that there will be no further payments of claims by NJ Pure except at the directive of the commissioner or the court. By the way, if you'd like a copy of the order, please email me. I'll provide you with my email address at the end so you can see what it says. There are also set forth in the order all the other powers of the commissioner as the result of the order of liquidation. So now we move into the New Jersey Property Liability Insurance Guarantee Association, also known as PLIGA. So this is a not-for-profit entity created by New Jersey law, and it's an organization that has been set up to deal with insurance companies that otherwise go insolvent or running out of money or a loss of money. So now Pliga will be taking over these covered claims. Unfortunately, these covered claims has a $300,000 maximum per claim limit. Most everybody in New Jersey has limits of $1 million per claim or 3 million in the aggregate. So clearly, there's a big difference between 300,000 and $1 million. This doesn't offer any more protection, and we'll have to go through the process of these cases. Now, the economic issues associated with NJ Pure are not new. They've been struggling for some time. So that if the plaintiff in these cases, or more likely the attorneys, have been watching NJ Pure, and then leading up to today or earlier this week, we're probably anxious to try to resolve as many of this no malpractice claims as possible when you had $1 million of coverage. 300 is a lot lower. Will that create a lower expectation of the plaintiff bar and or the alleged injured parties to take the 300, or are the claims as such that 300 is not adequate and these cases will go forward? So what do you do, or what are your options? There are limited options, but let me break it down in terms of those where there's been no filed claim and those where there's active claims. If there's an active claim, the Pliga most likely will maintain or keep the lawyers engaged who is defending the doctors in these med mal cases, but the coverage is limited to $300,000. The problem is that you can't now go buy a policy elsewhere to cover an existing claim. No insurance company will write that. I'll come back to in a moment to what that means. So can you get replacement coverage? And there are opportunities. I'm not really sure at the moment how they are priced, to buy some type of tail coverage to cover a potential claim that may be filed in the future. So I'm talking about those physicians who have not, there's been no claims against them, but need some type of coverage. There's two types of gap coverage. One is called a gaps claims made policy, and one is a standalone tail policy. The gap claims made policy will give you the difference between 300,000 and $1 million, basically 700,000 on top of the Pliga benefit. And this policy is an annual renewal. You'd have to price it. There are a number of insurance companies out there writing these gap policies: Mag Mutual, Conventus, and Princeton Medical Protective. There's another type of policy called, as I mentioned, the standalone tail policy, which goes into place for a longer period of time, but most likely are more expensive. The companies that seem to be writing those policies are the Positive Physicians Insurance Company and TDC Specialty. And those are the companies that I'm aware of. Again, thank you to Henry to give me this information, where you may want to turn to find out what your options are, what the costs are, and for you to make the determination, is it worth it or not? You know, by definition, insurance is just that. It's insurance to protect you in case something goes wrong. And we know we live in a litigious society, so I would definitely recommend against being bare and taking your chances with Pliga. You need that coverage because you never know what's happening. You need to make sure all your medical records are up to date. Monitor correspondence that's coming from NJ Pure after the court hearing earlier this week, as well as positioning yourself for the next go around in terms of claims that could haunt you. Clearly, you know, because of the statute of limitations, depending upon do you have an adult patient population? Do you have a pediatric population? Pediatric population, the statute of limitations goes a lot longer. Adult statute of limitations is basically 2 years from when a reasonable person would become aware of a potential claim. That's a change in law of a number. That change occurred a number of years ago, but pediatric clearly is age of majority plus the 2 years. It could go on for a longer period of time. I know some of the questions that have been presented prior to now relate to, well, how do I protect myself in terms of assets? Because if I'm involved in a case right now and I'm limited to the 300,000, can they come after me, personally? And the short answer is yes, they can. There are lots of physicians and lots of people, whether you're physicians or other professionals, are always looking for asset protection. So how do I protect my home, et cetera, my bank accounts? And asset protection is a vehicle to protect assets. But if you're doing this as part of avoiding creditors, then some of those asset protection techniques are not going to work. A lot of asset protection vehicles to protect the professionals really need to be part of an estate planning process. So it's not geared towards avoiding creditors. So estate planning is part of what you do and how you approach it. But if you're already involved in a case, a pending case that's been filed, moving things around is going to be problematic, especially if it's depending upon how close or how old this particular case is and the timeline of the asset protection moves as part of an estate planning technique. Plaintiffs and plaintiffs' attorneys will do whatever they can and scorch the earth to find money available to satisfy the demands of the plaintiff doctor as well as the lawyer that's hunting around. Let me pause at this point. I've covered a lot of material. I'd like to be somewhat conversational, and I also want to be respectful of your time and respectful of some of the questions that you may pose. So, Doctor, are there any hands raised at this particular point in time?
Yeah, I see Dr. Azzariti, Assemblyman Dr. Azzariti actually has a hand raised.
Mm-hmm.
Hi, hey John, and hey everyone. Thanks for putting this together. I appreciate it.
Hi, John.
John, I have two questions, if I may. The first regards the PLEGA coverage. So it's $300,000 per claim, and typically if you have a million, it's per claim, then it's 1.3. So there's an aggregate of 3. So is there a limit as to how many times you can go to that well, or is that the aggregate? Is 300,000 the aggregate?
My understanding it's 300 per claim.
Oh, okay. And just, I guess, not a question, but my understanding, what I was told, is that regarding the PLEGA coverage, that also includes legal fees coverage. Whereas typically, I believe, malpractice claims that the limit, the $1 million, is just for the award. Is that right? Is that your understanding?
I think I think the legal fees are in addition to the 300, but I will confirm that for the audience.
Okay. All right. Thank you, John.
Doctor, any other hands up?
I'm looking. Anybody else with any questions? Currently, I don't see any. From our legal team, Josh or Larry, any questions, comments?
Yeah, John, I really appreciate you giving this talk. I mean, to what extent do physicians need to worry about this? What's your sort of your handicap of the real risk here? Do you see this as something that's broadly going to be occurring, that there will be a significant number, or really any significant number of physicians who are going to be in suits where an award is made over $300,000, and then the, and then to what extent is it the physician's personal assets that are really on the line? I guess I kind of want to just get that sort of that
Yeah,
fine point on that
yeah,
risk.
yeah. That's a good question. The first part is maybe it's the likelihood of the $300,000 covering a claim. I don't think it's likely at all, because clearly the plaintiff bar, when malpractice cases are difficult to pursue. You need, a lot of records. You need a lot of experts. They take a long time to get to court. So there's a huge investment by lawyers. Again, we don't do med mal because we're on your side, just to kind of disclaim that. But there's a lot of economic out-of-pocket investment for the lawyers to pursue represent a plaintiff in a malpractice case. If they're looking at easy money at $300,000, they're probably not going to do a whole lot of work, because the payday is low. That typically lawyers get a third. So a third of 300,000 isn't a de minimis amount of money, but in terms of all the effort and time they've put into the case, it's not a lot of return. So I think, again, all cases are different, all injuries are different, all the proofs are different. It seems to me, depending upon the perception of the financial wherewithal of the doctor, a plaintiff's attorney is going to go for more than $300,000. There could be, new cases filed quickly, subject to pliga, and maybe they feel they don't have to do a whole lot of work, and get a quick payday. But I don't see that happening. Most malpractice cases, the allegations and the damages are usually pretty significant. We're working with one client of ours. It's an excess coverage claim. The doctor involved has traditional med mal, not subject to pliga. His lawyer wasn't able to settle it, and he's got coverage of $1 million. This case is probably going to come in excess of $5 million. Fortunately, over the last several years, we haven't seen many excess coverage cases. Most come in within the limits, but we have seen some significant awards where the medical practice has had to write a big check, and physician owners have had to either take less comp that year or contribute to it to make the case go away in a settlement. The medical society historically has taken the lead in med mal reform in New Jersey. Things have gotten a lot better over the years in terms of numbers of cases filed and settlements. And the medical society, again, when I talk about that, through legislative efforts many years ago. But there's still, some bad cases out there, unfortunately, because those things happen. I think, and so I think some doctors are going to be forced to potentially write some big checks to settle these cases. You don't want to go before a jury because you have no control over what that could happen. And that's when we talk about some of the asset protection strategies physicians can engage in, but again linked to estate planning. One of the other things, I don't know how many. I think it's probably a public record. I don't know the specifics in terms of how many subscribers NJ Pure has at the moment. And I guess they're going to probably need to submit to the commissioner how many active cases there are, and whether that universe is small or large. Clearly, if you're one of the doctors, it's of serious concern.
Yeah, absolutely. No, I appreciate that. There's a question in the chat, actually. Dr. Henry Dindial, do you want to reference that?
Sure. So Stephanie Hammond said, that one of the slides mentioned, oh, sorry, I just scrolled away. Something about having to file within a specific time frame, 90 days. If you can just clarify what that referred to.
Sure, let me go back. Yes, so if you're that relates to the regulations under PLEGA. Now that the order occurred this week, there'll be more communications coming from Dobie to policyholder subscribers as well as those that have existing claims as to what they need to do and the timeline. There is and it also relates to potentially plaintiffs as well. So I don't think you need to do anything at the moment, doctor. You'll be getting communications from the state on what your options are next, consistent with the legal rules and regulations and statutory framework.
Thank you.
Sure. Good question. Thank you for asking that.
And then I had a question. So when we look at, the loss of a malpractice liability company, that leaves less competition in the market. So is there a way to look at the landscape? Are there other companies that are self-insured that might be under difficulties as well, that we need to start thinking this might be a shift in general?
Well, as a result of, again, a lot of great work by the medical society over many years to deal with the situation, there has been a reasonably robust med mal market here in New Jersey. Different states who have different regulations, there could be many of them, but you never know how financially secure they are. One of the key things that we have in our regulatory framework is if you're going to get into this business, you have to have the minimum financial wherewithal to handle these cases. When a carrier comes into New Jersey, they price their premiums low to get subscribers to abandon their existing companies to come to them. And then over time, premiums go up, especially as malpractice cases mature, because we do know, it takes time for when a case is filed to any type of settlement and or reward. It could take years. So usually these companies do very well for the first 4 and 5 years. At that point, things begin to change, and that's when they start writing checks. I don't think this is indicative of the industry. It could be, and again, I'm not articulating a criticism of NJ Pure, but it could have been a combination of bad timing, not getting enough premiums in, being on the losing side of a lot of key cases, and at some point, they run out of money. You play the game like all insurance companies. You have a lot of people paying premiums, and you try to pay out less, whether that's health insurance, malpractice, or what have you. And perhaps people left, and the good doctors. That's bad. I mean, just because you get sued doesn't mean you're a bad doctor. But those who did not have a history may have searched around, got a lower premium, and then you have less people paying into NJ Pure, which definitely began to happen because it becomes a race to the bottom. And who's left? Those that are left are those who have pending claims or a bad history, and they can't get insurance written elsewhere. So I think maybe it's a long-winded answer to your question, Doctor, which I apologize. I don't think this is necessarily indicative of the industry at all.
And then it seems like it sets them up for failure, right? If they can't write new policies, then how do you finance,
It becomes a runoff, and then what we saw probably over the last 6 to 12 months, again, I don't think NJ Pure's stress point was all that secret. I think a number of professionals began to see the problems that were coming about, and then doctors began to move to other companies. Josh, you have your hand up.
Yes, thank you. So recently, litigation involving parties who are covered by NJ Pure, physicians who are covered by NJ Pure, um, those those lawsuits were recently stayed around the time that the liquidation was filed. In fact, the Medical Society recently submitted an amicus brief on a policy issue in a medical malpractice case where it just so happened that it was a New Jersey pure covered physician, and that litigation was stayed, meaning that we'll have to wait an extended period of time to get a policy resolution on our sort of unrelated issue. But I'm curious, and I don't know that this is an answer that exists. I don't know that anybody knows the answer to this question. But do you know if there's an anticipated time at which those litigation stays will be lifted, and litigation can proceed, presumably with PLEGA coverage?
I think we're going to, now that, again, the order was just filed 2 days ago, or 3 days ago, we're gonna learn what that timing is probably in the next week or two, Josh. Because we've got to let the commissioners, it was approved, their order of liquidation, what their obligations are. They probably, let's freeze everything. Let's do an analysis of what's going on, who's covered, who's not covered, what are the pending claims, what are the plaintiff's demands, and then they just got to, and they got to identify who the lawyers are. The lawyers they got to work out how the lawyers are going to get paid. So there's a lot of work for them to do now that the order of liquidation was approved on the 27th of July. I'm glad we're doing this tonight, not last week, not knowing where the order would come through.
Right.
The timing was pretty good on this.
Yeah.
Yeah,
We'll stay tuned.
Yeah, thank you. Jessica raised her hand. It's somewhat related. Jessica, if you want to unmute, you can ask the question. Otherwise, I can read it from the chat.
I see the question. I received notice of a case I'm involved with this week. Do I wait for PLEGA to assign a lawyer, or should we look to hit our own or hire? I think the word meant to be hire our own lawyer now. I think you would want to seek independent legal counsel to assess your particular situation and what your options are in your particular facts. It's not likely that lawyer is going to handle the case. I think you'd want to see who the lawyer is that is going to be assigned to the case. And again, I've been doing this for 40 years, and every now and then a client will call us and say, hey, I'm not that happy with the lawyer that the insurance company has hired to defend me. Will you either work in tandem or keep an eye on or shadow what's going on? And we've done that over the years. But I would have to say that typically the med mal lawyers that have been hired by the insurance companies to defend these suits are very good at what they do. But again, in light of the uniqueness of the situation, hiring your own lawyer to get some advice as to how to proceed is probably a good idea in light of the timing of everything.
Thank you. Anybody else? Questions?
You're welcome, Jessica. Josh, thank you for your input. What do you hear among your constituents, among the members of the medical society? Do you believe from, anecdotally, that if, clearly it would probably reach out to you more often than they would me? Do you think this is a large universe or small universe of pending claims from NJ Pure it's
a little hard to know. I mean, generally, I figure if I'm hearing about something 2 or 3 times, that means it's happening far more out in the community. And I have heard about this. I mean, I think you can see that there are 22 people who are interested in learning about this at 7 o'clock on a Thursday night. I think there's concern. I know I've spoken with people who are at different stages. I feel like I've spoken with people at all of the stages, people who had coverage and now are covered by PLEGA, people who have claims that they expect to be filed, people who are in the middle of litigation. So that question about who's your attorney going to be when PLEGA takes over? Like, do they pay the same attorney that was previously paid by Pure? I think all of these questions are popping up pretty frequently. So yeah, my concern is that there's a bigger universe than we even realize of physicians who are going to be impacted by this.
Yeah, I ascribe to this same philosophy where there's one or two, there's many more. And again, I think if you've been the claim's been filed, that puts you into the PLEGA category. If a claim has not been filed, you need to find some type of replacement coverage going forward, and you need to have some type of tail coverage for anything that arose prior to the replacement coverage taking place. And again, and that gets you to the either the gap claims made policies or the standalone tail policies. Those are your options. But don't let any time go by before you do that, because once a claim is filed, then you're going to have a tough time finding any type of tail coverage. It'll be almost impossible. So that's something you need to get in place right away.
Good advice.
Terrific, thank you. And I think you also had on the slide, just maintain copies of all prior liability coverage. And
keep copies of all your policies for sure. Yeah.
And as always, document when you're right in the room with the patient.
Yeah. Yeah. Again, I think it's unpleasant to be sued. And it hangs over your head. You're working and working very hard. You're doing the best you can. Sometimes it's a bad result. It has nothing to do with your competency or what you did. It's unfortunately, it's part of the game at this point in time. However, the Medical Society has done a great job minimizing the filing of claims through legislative relief. It's something we continue to work on your behalf and all physicians in the state of New Jersey. But sometimes things happen, and that's why we all buy insurance and malpractice insurance. If there's something that I may have touched on and you'd like more conversation, on the slide is my direct line, and it rings to my cell phone. Or if you want to email me as well, happy to respond back. If there's copies of any of the documentation I made reference to, happy to respond. And so either call or email me, and we'll get it to you as quickly as possible.
Wonderful. Well, thank you very much. It was timely, it was informative, and you made it clear. I thank you again, John, for presenting. Thank you to Josh and Larry, the staff, for setting it up. And for everyone who attended, we do continue to do our monthly lecture series, so please look for those announcements in the e-news. If you don't see your e-news or you're not getting it regularly, please reach out to MSNJ, and they can show that you're on that list. And again, we thank you for your presentation tonight.
Thank you for having me, Josh, Larry, Doctor, and Henry Kane, as always. Thank you so much for having me. Look forward to working with you in the future.
Thank you so much. Take care. Have a good night, everybody.